Good morning and welcome to the First District Court of Appeals. We have three cases to be argued this morning. When I state the case, if the attorneys arguing could please rise, state their names and their readiness to proceed. The first case to be argued will be C-240272, Robert M. Lucas, DMD versus Ohio State Dental Board. Thank you. Then the second case is C-240299, which is State v. Thacker.
Robert Wessels, on behalf of the state,
Thank you.
Good morning, Your Honor. Brian Goldberg on behalf of Mr. Thacker. Appellee, you are ready to proceed.
Thank you. And then the last case is C-240093, which is State v. White.
David Hoffman for the appellant and are ready to proceed.
Okay, thank you.
John for the plaintiff, appellee, state of Ohio, ready to proceed.
Okay, thank you very much. And I will be keeping your time. The green light is go. Yellow light means you have about a minute left, and the red light means that your time has expired. Mr. Lyons, whenever you are ready, would you like to reserve any time?
Yeah, what do I have, 15 total?
Yes.
I'll reserve 5.
5 minutes? Sure.
Well, please, the court, it's always a privilege to be here. Probably been here over 100 times in 48 years. That probably reflects what I've been doing in the court below. I want to apologize to the court professionally, beginning here this morning. This brief was written by my associate who now practices in Louisville, Kentucky, and it's my responsibility, my name's on this brief, but there's a 2 times I've used the word ignorance in this brief. You probably saw that. And my suspicion is next time I'm before Judge Triggs, he'll probably remind me of that. But I want to apologize for that use. That's not a word that's appropriate for a brief before the district, the first district, under any circumstances. This is a very interesting case. I want to begin, if I may. It seems to me Ms. Bachbrader's brief sets it very clearly about what we're talking about here. In her brief, she quotes Henry's Cafe, which says this: Revised Code Section 119.12 does not allow courts to second-guess an agency's choice of penalty if the agency's finding, in other words, the converse is true. It allows them to second-guess. Agency's finding of a violation is supported by proper evidence, and the penalty is one that the agency is legally authorized to impose. And that statute specifically states this, at subparagraph end, quote, the court may affirm the order of the agency complained of in the appeal if it finds upon consideration of the entire record and any additional evidence, the court has admitted that the order is supported by reliable, probative, and substantial evidence and is in accordance with the law. It's my position, Your Honor, that in this case, the board did just the opposite. I always look at a record like a box. You open up the box, there's nothing in it. Hearing begins, trial begins. Everything that's allowed in evidence is in the box. You close the box. You see this every time you sit in a court of appeals. You can only decide the case on what's in the box. In this case, once the box was closed, there was no evidence in that box of the outcome, the death of the young man, of the causal relationship, if any, between the events and the death. None whatsoever.
So just so I understand, you're not appealing the violation findings, you're only appealing the sanction.
Exactly.
And you're saying that there was no evidence in front of the board that there was a death?
None whatsoever. None whatsoever. There was no evidence.
Then where did they come up with that?
That's my point.
Okay.
There was no evidence in the record. As a matter of fact, the hearing officer concluded that the death was not related in any way.
Well, wait, there was evidence that the person passed away, right?
Right.
But you're just saying there was no evidence of the cause of the death.
Exactly.
Okay. All right.
There wasn't evidence of a death, but there was no finding that anything Dr. Lucas did or failed to do in any way was related to the death, any at all, whatsoever. by the hearing officer.
Well, I mean, I'm going to quote here from what the hearing examiner statement was that, let me find it, okay. So part of the statement was that had patient one's blood pressure been properly monitored and had respondent's office obtained better records regarding patient one's medical history, it is quite possible that the results would have been dramatically different, as his condition could have been more promptly and appropriately addressed. Now, I
Possible.
realize he didn't say the word death here, but it's quite possible that the results would have been dramatically different.
Possible has no probative value at all. None whatsoever. Not when it comes to causation. It's as if it didn't happen. So there's no, he didn't say probable, he said possible. And it's very speculative to begin with. So therefore, there's no, remember, the operative words here, probative, evidence in the record. The board, when they issued their decision, says this. This is the core of my argument. In its expertise, the board finds that due to the seriousness of the situation and the outcome of the surgery, now the only outcome they're talking about is the death of the young man. A suspension period, continuing education, and probationary period was appropriate, unquote. In our view, that's totally inappropriate. It's outside the record, and that their decision was based on nothing in the record that supports that finding whatsoever. That,
Why
what you just quote.
Why can't the board, though, because I'm looking at these two sanctions, and these are kind of, they don't seem that bad. I mean, continuing with the procedure despite the high blood pressure readings was one of the violations, right?
Right,
And then the other one was failing to document what was going on.
right.
Why can't, though, in determining an appropriate sanction, the board look at the fact that somebody actually ended up dying?
They can, if the death is related to the conduct.
So there has to be a finding of causation, is
There
what
has
you're
to.
saying.
To be probative, look, we got to go to the words that we use as lawyers.
Mm-hmm.
Probative, evidence. There's no probative evidence that there was any relationship between the death and the conduct. And therefore, by injecting that into their decision, in our view, it was outcome bias, clearly. Let me propose the following to you. Let's assume, hypothetically, that the young man goes exactly as the chronology. He gets the medication. Dr. Lucas comes in, as he did, resuscitates the patient. He's back at baseline, which he was, and he went home. End of story. That never went to the hospital, never died, just went home. Do you really think we'd be here in front of you? No. Because there would be no outcome that would be register in the factoring. I guarantee the board wouldn't issue a 4-month suspension on those facts. And that's the way you have to look at it. That's exactly what happened here. You have to completely eliminate the outcome, the death, to the analysis. And by
You're saying we have to completely eliminate it because there was no proof of causation here.
it's not an evidence. It's not, here, I know what you're saying. It says, the statute says, and Ms. Broadbecker is so right, citing that case, does not allow courts to second guess, in other words, the converse is, if the penalty and agency in finding is supported by proper evidence. Where's the proper evidence of any relationship between the death, the outcome as they talked about, and the conduct? There isn't any. And to so inject that into their analysis, in my view, is very prejudicial to my client.
Could we read the outcome as not being necessarily the death, but could the outcome be the fact that there was this emergency situation that happened?
No. How could you read that? It says, I know what you're saying. That was the magistrate's reasoning. That you can determine it both ways. How can you read it any other way when it says a suspension? It said the outcome due to the seriousness of the situation. That's what you're talking about. And, not or, and the outcome of the surgery. That's what the board said. The board didn't say the seriousness of the situation, whether it be the death or the conduct or whatever. It said and the outcome. The only outcome here is the death they're talking about.
Are you saying, though, that in the prior hypothetical that you gave, where the person goes home and everything's fine, that sanction should be the same as a sanction in a situation like this, where the person ultimately died?
What I'm saying is that it shouldn't be the same. It's not nearly as serious or provocative as the one that the board has imposed upon my client. They're imposing a sanction based on a fact situation that doesn't exist, i.e., that his conduct in this set of circumstances caused the death of the young man.
So they have to ignore the death?
Absolutely ignore the death, as if it didn't take place. They didn't. They incorporated it into the decision-making. And, by the way, we had no chance to even talk about that with the board. That was their final conclusion. They came out and said, this is it, and this is based on this. We had no chance to then rebut that or talk about that. I think this court has the power to impose the original penalty by the hearing officer, in this case, by virtue of the fact that the hearing officer based it on probative evidence appropriate to the statute in accordance with the citations by counsel in this case.
What's our standard of review?
Abuse of discretion.
So whether the trial judge abused it?
This is weird here. It's almost an abuse of discretion. You have almost one on top of the other. But discretion can only exist, reasonable discretion can only exist when you have probative evidence. There's no evidence here in which to exercise discretion. To me, it's a total abuse of discretion because the board manufactured a component, an element of evidence on which they based their decision that did not exist. That's an abuse of discretion. When I went through this at first, I said, what's the court supposed to do here? What am I asking you to do? Well, originally I wasn't sure what I could, but now I see it. Quote, the court may affirm the order of the agency complained of. Well, the court may not affirm. You can go either way. If you find that there was not made reasonable, appropriate, reliable, and substantial evidence, there is none. That's my position.
Mr. Lyon, if you'd like to reserve time.
Thank you very much.
And I'm going to give you an extra minute. I got too involved with what he was saying and didn't stop him in time. So since I'm going to give him his 5, I'm going to give you an extra minute.
Thank you. May it please the court, my name is Catherine Bachbrader, representing the State Dental Board. There's no dispute that Dr. Lucas committed the violations charged in this case. He violated the standard of care by allowing anesthesia to be initiated on a patient with a heart condition and a shockingly high blood pressure of 240/161. He also violated the standard of care by failing to document his treatment. He doesn't dispute these violations or that they are supported by reliable, probative, substantial evidence. His only argument relates to the sanction imposed by the board. And on that issue, this court is bound by the Supreme Court's decision in Henry's Cafe, which held that when charges are supported by reliable, probative, and substantial evidence, the court cannot modify the sanction if it is one that the agency has the authority to impose. This court should therefore affirm the decision of the lower court. As Mr. Lyons noted, the Henry's Cafe case holds that the court can't second guess if the violations are supported by reliable, probative, substantial evidence, which is not in dispute here. There's no question the board has authority to suspend a license when someone violates the standard of care. He's pointing to the rationale stated by the board, which states that in its expertise, the board finds that due to the seriousness of the situation and the outcome of the surgery, suspension is appropriate. Admittedly, the reference to the outcome, that word outcome, is ambiguous, but it doesn't necessarily refer to the patient death. The outcome, it could refer to the consequences of Dr. Lucas's practices. The hearing examiner noted a lack of proper protocols and supervision, and the events in this case unfolded in the way that they did because of the manner in which Dr. Lucas ran his practice. These charges, if you look at the facts, are not generally about the direct actions of Dr. Lucas, but about his failure to establish protocols and supervision over his staff. Mr. Boone started anesthesia without Dr. Lucas in the room, without reviewing the patient's vitals with Dr. Lucas, because Dr. Lucas regularly allowed him to do that. He didn't document things contemporaneously because Dr. Lucas never required him to. It was his regular practice to do it at the end. So the outcome of the lack of these proper protocols was that Dr. Lucas was not supervising. Mr. Boone had free reign to start anesthesia without ever discussing with Dr. Lucas and using his own judgment, which in this case was horrifically bad.
Oh, wait, what are you saying that they're referring to as the outcome?
The outcome of his failure to have protocols was that his staff were basically in charge. They had free reign to initiate anesthesia without Dr. Lucas
So
supervising it.
you're arguing that outcome doesn't mean what happened to the patient?
Correct.
What if it did?
Or as, well,
I mean, would that have been proper then? If they in fact were referencing the fact that there was a death or a serious injury here?
the hearing examiner did not conclude that Dr. Lucas caused the patient's death. So I would agree that unless the board overruled that, that is the
So
finding.
that
of
would
the
be,
board.
if the board was in fact talking about the death of the patient, that would have been improper to enhance the sanction based on that.
In this particular case.
Okay.
Yes, because they didn't change that determination.
Okay.
But this court should assume the regularity of the proceedings, and it was Dr. Lucas's burden to show that the board was considering something improper, and they did not convince the magistrate or the judge below of that. The magistrate concluded that the word outcome was not referring to the death, and the court didn't abuse its discretion in coming to that conclusion. Abuse of discretion is not merely error, it's being unreasonable, arbitrary, or unconscionable. And that term does not clearly refer to the death. It's not unreasonable or unconscionable that the lower court found that it did not refer to the patient's death. And
So let me ask you a question. So there's no argument here that this sanction was permissible. I mean, let's set aside the word, the outcome, setting that aside. Based on the doctor's actions, the sanction was a permissible sanction under the statute.
correct.
Okay.
Correct.
So there's no dispute about that. So could the board have increased the sanction? That's a permissible action as well.
Exactly. They don't have to accept the decision of the hearing examiner, even if they change nothing about the hearing examiner's
Which I don't
findings and
think they
conclusions, and
did.
They did not. When a board considers the sanction to be imposed, when they consider the violations, they only can consider those facts, what's charged. When they're considering the sanction, the 10th District has held in the Mascherette case and the White case that they can consider aggravating and mitigating factors such as whether the person showed remorse, whether they lied about their actions, whether they tried to cover them up, any number of aggravating or mitigating factors. So they're not limited to the hearing examiner's rationale, the findings and conclusions. It has to be in the evidence, but they can consider other things in the evidence besides just the straight violation. And I would disagree that if the patient had, if this had a different ending, if the patient had gotten up and walked away and not had a problem, there would still be a case here. He still violated the standard of care. If he would have, if Dr. Lucas and this patient would have had, a luckier day, if he had continued to, after he had been revived, not have additional issues in the hospital, this would still be a case of standard of care. He did not have proper protocols in his office, regardless of whether the patient lived or died. This is a case of standard of care, and the board absolutely had authority to suspend his license for those violations.
Okay, one more question, and then I will let you carry on. So the seriousness of the situation and the outcome, that's what the board based its sanction on. Are those two separate justifications, or are they a justification combined?
It does have an and, so I think they're talking about both things. I don't know if it's combined into one, or, that's difficult, again, that's difficult to say, but, again, the Common Pleas Court found that it was not relying on just the death or on the death, and you have abuse of discretion to stand before you, and it was an abuse of discretion for the lower court to read those words, however clear or ambiguous they were, and come to a conclusion that it was not relating to the death. It was not abuse of discretion for the court to find that. and for that reason, you should affirm.
Sorry I'm so slow here. So if I understand your argument, you're saying that it would have been improper for the board to enhance the penalty or the sanction based on what happened to the patient,
Based
because there
on-
was no causation found. Is that what you're saying?
It would have been improper for them to do it based on a finding that Dr. Lucas caused the patient's death, because the
Okay.
hearing examiner did not find that.
And so just tell me again what you think outcome means if it doesn't mean the patient's death.
To me, my reading of it is that the outcome means Dr. Lucas's actions were, in this case, were setting up the protocols and standards in his office. Those standards were that his staff could start anesthesia without him being in the room, without checking with him to see if the vitals were okay for that patient. And because he did that, Mr. Boone was able to do that on his own and use his own judgment and start the procedure, even though Dr. Lucas testified if he had known that was the blood pressure, he never would have allowed him to start it. He agreed that it was a violation of the standard of care to start anesthesia for this patient with that high of a blood pressure. So the outcome is that his actions were setting up the protocols or failure to set up protocols, and the outcome is that his staff, who are not dentists, who are not oral surgeons, it was an EMT, had authority to take actions that a dentist should have been.
So the outcome of continuing with the procedure despite the high blood pressure readings is that his staff had the authority to continue with the administration?
That basically his staff were in charge.
Okay. So that's a reading of what the board could have meant by outcome.
Correct. And the trial court found something slightly different, but the trial court found that it was not based on the death, that it was based on standard of care and proof of correcting those standards. And that's not an unreasonable or unconscionable determination that you should find as an abuse of discretion. However, if you disagree, if you find that you believe the board considered something improper, the resolution is not for you to order what the hearing examiner ordered. The board still has the discretion to consider the aggravating and mitigating factors in this case. As we cited in the brief, in cases where a court reverses an agency's decision on a sanction when they find, or for whatever reason they find, you would remand it back to the board for them to decide. You can give them direction to say, don't consider this, don't consider that, or consider this, but it should still be their decision and their discretion as to what's appropriate. Under the Pons case, they are the experts in the technical and ethical aspects of their profession, and it should be the board that ultimately decides that with direction from the court if you believe they did something improper. So I would ask you to affirm the decision of the lower court. On the alternative, if you find that there was an error, that you direct the common pleas court to remand back to the board for consideration of the sanction. Thank you.
Thank you.
You know, due respect, I think the board really wants to have it both ways. They want to be able to say that what the board said in this case is meaningless. Ignore it, it's no big deal, because they have the discretion to do what they did anyway. That's not what happened here. The board didn't say, by the way, they embraced the finding of fact and conclusion of law. This was a 4-day hearing with expert witnesses. It was a very 4 or 5 experts in the record. They didn't say, based on the record that we have, we really don't think that's sanctioned enough. We think it should be more. They didn't say that. Could they have said that? Sure. They didn't say that. What they said was, we've embraced the finding of fact and conclusion of law. They didn't ask for more testimony. They didn't say go back and get. They added something that's not in the record. They added to their analysis the fact that the outcome was part of their consideration. That's where it was terribly wrong here.
If we were to determine, if we were to agree with opposing counsel that the word outcome is ambiguous, what should we do with that?
I don't see how you can.
If, it's hypothetical here. If we did.
If you were to find it was ambiguous, you have to send it back then for clarification to the board. and allow us to then confront that and find out what they meant. At the very fairness to Dr. Lucas, to give him, if you think it was ambiguous, okay, then I will embrace that. But you have to give us an opportunity to go back and confront that with the board to find out what they meant by it. I'm not sure what that looks like.
Do you agree that if we were to agree with you, that it would have to go back to the board for sanction rather than us imposing?
I think
the
this
prior
is where it
sanction?
gets really weird. Administrative law is not my favorite topic. I think you have I'm asking this court to order the board to impose the original sanction. That's what I'm asking you to do. I think you have the power to do so based on the statute and the case that Ms. Bachbreiter cited for you as the seminal case on this issue. You can do that. You can go back and you can apply it and say it was wrong. The original sanction is one that should be in place because the one they imposed is based on not probative substantial evidence, but on outcome bias. And when you read the chart or record, if you haven't already, you'll see outcome biases all over this thing, especially with the expert from the board, basing almost all his testimony on the fact that the young man died. But that's what I'm asking. Now, what's your choice? Your choice is to do what I'm asking you to do, or to me, at the very least, send it back for reconsideration, to give us an opportunity to at least confront that issue, because we were not given the chance. That was right at the final hearing. They came out, they get a decision, and then they told us why they did their decision, and frankly, we were quite surprised. So I think that's where it sits. Thank you so much.
Okay, thank you. Your case has now been submitted, and we will issue a timely decision. Okay, the next case up is State v. Thacker. Whenever you're ready.
Good morning, Your Honor. I'd like to reserve maybe 4 minutes if I can.
Sure.
The topics at issue here on this appeal, I think, are pretty broad, so unless the court has any pressing questions, I would like to move into what I believe is the heart of the matter of the state's appeal, which is I believe that the court below used the wrong analysis in coming to its determination post-Bruin. So obviously, Bruin, since it has come out, has kind of put a lot of the courts in a tizzy as to how to interpret these constitutional issues. The error, as I see it in the court's analysis, is that it applied a more modern understanding of juvenile law and the determination of whether or not a juvenile adjudication should be treated the same as a felony conviction for the purposes of the Weapons Under Disability statute. So what I mean by that is it was the state's proposition below that there's nothing historically to suggest that the two should be treated differently. And the court, I guess's analysis was that there has to be some sort of special justification for a juvenile adjudication in the historical record in order for the state to sustain its burden. I think that's erroneous for 2 reasons. The first reason is I think that issue had already been decided for the most part by the Ohio Supreme Court in both the Carnes and the Buttery cases, which are cited in our brief. In both of those cases, the Ohio Supreme Court has said, at least as far as the 14th Amendment is concerned, there's no reason to treat a juvenile adjudication as differently than a felony conviction for the purposes of a disqualifying condition under the Weapons Under Disability statute. It's not treated like a conviction. It is a separate, discrete, disqualifying condition. That is to say that the Ohio legislature has determined that a juvenile adjudication, even though it was one that was committed by a juvenile, is sufficient to create a risk of harm to the general public such that someone can be dispossessed.
Let me ask you this. So, sir, when I read the judge's decision, it looks like she made a blanket prohibition against charging adults with weapons under disability, with the predicate offense being some felony they committed down in juvenile court. Is that that's the way I read it? Did you read it the same way?
That's the way I read it. The court sort of adopted a decision of a different judge
Right.
that wasn't appealed. That decision, I believe, wasn't appealed by the state because we were still kind of figuring out how to interpret Bruin and trying to create a more thorough record. So while I think it was somewhat erroneous to just out of hand adopt something that relies on the record that was before a different judge, I think we've met the standard that we need to meet in this case. I read the judge's decision to say that not as a general prohibition against anyone who's committed felonious behavior, but specifically the issue with the judge below was that because a juvenile adjudication under our own modern interpretation is different, the judge, at least in her incorporation of the Booker decision, cites, for example, a lack of a jury trial as one of the things that would make a juvenile adjudication different. So as I would read the court's opinion below, is that any juvenile adjudication could not be used to dispossess someone from using a firearm. So for example, under the weapons under disability, that could be a juvenile adjudication that involved a felony offense of violence or, for example, a felony drug offense. I said there were two reasons that I think the analysis was incorrect. One, because I believe the Ohio Supreme Court's opinions in Carnes and Buttery is still good law. The second is because what Bruin requires, and I think what was confirmed most recently in the Rahimi decision, is that when we look back, we have to look back at the principles that existed at the time of the founding, both in 1791 and 1868, the founding, the ratification of the Second and 14th Amendment, respectfully. And at those times, I think what the history shows is clear is that we didn't have the same exact procedural safeguards that we did at the time. That, though, is not dispositive of this issue. I think what the law clearly shows is that felonious behavior, when committed by someone, regardless, not entirely regardless of their age, but those who were who considered capable of understanding their the ramifications of their conduct, that would be someone who's over the age of 7. We're still punishable. We're still able to be punished in line with those who would otherwise be considered adults. It's a little bit difficult because the distinctions between a juvenile as we understand it today did not exist at the time of the founding.
And so you're asking us to just ignore those distinctions in coming to this conclusion?
I wouldn't say I'm asking you to ignore them. Obviously, what I would say is I'm not asking the court to necessarily ignore them. What I'm saying is that Bruin requires us to look back at the principles that existed at the time of the founding. And so in consideration of the fact that the principles at the time of the founding did not treat adults and juveniles separately, when we look at what is actually at issue here, which is the felonious conduct as the determination of someone's, whether or not they're dangerous enough to have a firearm, I don't think that the fact that we have now provided more protections for juveniles changes it when we look back in history at the principles as they surround firearms.
Or the fact that the juvenile in today isn't actually convicted of a felony.
Correct.
So you want us to just equate the two, adult felony with a juvenile delinquency?
I think for the purposes of the historical, when you're looking back at history, you have to equate the two, because I can't go back past a time where juvenile courts didn't exist and pull up a law, that it just didn't exist back then. Juveniles were subject either to the state or to the people that were in control.
Well, they executed 14-year-olds, apparently.
Correct. You could be executed, you could have your entire estate removed if you had done some of these acts that were considered felonies at the time.
So you're talking about taking a category, a felon, and saying that we can disarm these people.
Correct.
Indefinitely.
Correct.
What is an example of a founding area law that permitted permanent disarmament of felons?
So I don't think there's an exact law that, I would say two things. I don't believe that there is a specific law that that necessarily said that it was only firearms that could be. There's no exact one-to-one equivalent for Ohio's weapons under disability law. What we do know from looking back at the principles is that people who were to be so dangerous as to be determined to not be trusted with firearms could have their firearms completely dispossessed. In our brief, both below and to this court, we've cited several distinct categories of who those people might be. In addition, we've also cited the proposition that specifically for felonious behavior that was committed back at the time, someone could have, like the court had referenced, could be put to death or could have their entire estate completely subsumed, or have their entire estate completely taken from them, which we believe would subsume disarmament. That is to say that if we're looking back at the principles at the time, I think it's difficult to find that someone who had committed such behavior would be subject to the right to have a firearm when so many other categories of people were able to have their firearms completely dispossessed.
But wasn't the key things that the Rahimi court, the Rahimi majority looked at was the temporal piece of this, just the fact that this is not a permanent disarmament?
So one of the things they cited in the Rahimi decision is there were a number of things that they were not deciding at that time. One of the things that they were not deciding was whether or not someone could be permanently dispossessed or whether or not that dispossession relates to a specific crime.
But the court did emphasize the fact that in Rahimi, it was the disability lasted only as long as the restraining order was in place. So, and it did discuss the limitations as far as how long somebody could be prohibited from carrying a weapon. And are you saying that that's not something that we should consider?
I wouldn't say it's something that the court shouldn't consider. I think what I would say is Rahimi doesn't definitively, I don't think definitively speaks on that issue. For example, I wouldn't say that Rahimi suggests that there has to be a necessary limit on someone's ability to be dispossessed in order for it to be constitutional. One thing that they do say in Rahimi and in Bruin and in all of our Second Amendment jurisprudence, and it's confirmed again in Rahimi, is that firearm dispossession for felons is, and they quote it directly in Rahimi, is presumptively lawful. And so I think that's consistent with the historical tradition that we have. In regards to whether or not someone can be, I think there's a reference to permanent disability. I would submit to the court that it is presumptively permanent, that unless something changes, that the firearm disability will last forever. But unlike federal law, there is a method in Ohio where someone can be relieved from disability. Either someone can have their disability resolved under 2923.14, which is the relief from disability statute. There's also law in Ohio to suggest that if someone has their disabling condition either sealed or expunged, that also cannot be used against them to charge them with a conviction, with a weapons under disability charge. So I think in what I think the Ohio law does, if you read 2923.14, one of the conditions it sets is that they have to show that they've led a law-abiding life. I think that law-abiding life language comports with the historical tradition in a way that I don't think you have with some of the more federal analogs that are discussed in both of our briefs. One thing that I would say, to Your Honor, Judge Bach, in relation to whether or not Rahimi kind of changes the games and how it should be considered, what I would suggest is the range decision, which is, I think, what I would describe as kind of the landmark decision that dealt with someone who's convicted of a felony for lying in order to get food stamps. That one was deemed unconstitutional. It was actually before the U.S. Supreme Court, and Post-Rahimi, they sent that case back to that circuit in order to reconsider what I believe is the most important holding of Rahimi, and one that I think everyone but Justice Thomas were agreed upon, is that when we're faced here with determining, do we need something that is the exact language, or do we look at the principles? The principles are the thing that control, and I do think that the regulations that Ohio have align with the principles that we had throughout our historical tradition. I see that I'm on my yellow minute now, so I'll reserve the rest of my time.
Okay, thank you.
Good morning again, Your Honors. Just to follow up on something that came up earlier in Mr. Wessel's argument, I don't think that the decision by Judge Cross, which in essence incorporated the Booker decision from Judge Branch, says that juvenile adjudications can never be used for weapons under disability. If you look at the Booker decision, which is attached in the state's brief, it specifically talks in there about how Mr. Booker had been rehabilitated, he had completed parole within 4 months, he had been leading a law-abiding life since being released from DYS. So I think each case you have to kind of look at individually and look at the facts of that person, and do they pose a danger to society? And I think in Booker, Judge Branch looked at him and said, the parole officer said that he did amazing, he completed parole in 4 months. He's no longer a danger to society. I think if he had still been out committing crimes, had not been rehabilitated, then perhaps her decision may have been different. So I don't think it's just a blanket decision where no juvenile adjudications can ever be used for weapons under disability.
Let me ask you this, Mr. Goldberg. In Booker, he apparently did not know that he was under a disability. He purchased a firearm, right? He went out and purchased a firearm and answered all the appropriate questions.
Correct.
And in the Booker, it seems to me that not knowing about it's different than actually knowing about the fact you're under a disability. But nevertheless, it seems that the judge in that case actually applied the principles of the relief from disability statute kind of post hoc to Mr. Booker in order to dismiss the case. Would you agree with that?
I don't necessarily disagree with that. I think that was done in part. Yes, I would agree with that.
Okay, then I take it, I know the answer to this question, but Mr. Thacker never did apply for relief from disability.
Not that I'm aware of, no.
All right.
And for all we know, maybe he did not know that he was under disability. I mean, I think what we have to look at in this case is his disabling adjudication is a marijuana trafficking adjudication from when he was 16 years old. I think at the time of this offense, he was 29 years old. So we're talking about something that happened 13 years ago. And I think marijuana was treated much differently 13 years ago than it is today. You can walk down the street and buy marijuana legally now. You couldn't do that 13 years ago.
You still can't illegally traffic marijuana, though.
I agree.
And so I mean, I think like the idea of dangerousness when we look at drug trafficking goes to the whole concept of this is an illegal activity. Oftentimes there's guns involved, that kind of thing. I mean, so could we presume that a underlying drug trafficking is a dangerous act?
I think it can be. I think you have to go back and once again look at each individual case on its own. I don't think any two cases are going to be alike. And I know the Sixth Circuit recently, August 23rd, they released a decision, United States versus Eric Williams. It just came out a week or two ago. And in that case, they specifically say a crime that inherently poses a significant threat of danger, including but not limited to drug trafficking and burglary, can show that the offender is dangerous and that you could potentially then not make the argument that possession of a firearm is unconstitutional as applied to that person. However, the decision goes on to say that the district court should make fact-specific dangerous determinations after taking into account all the unique circumstances of the individual, including details of his specific conviction, and you may evaluate the defendant's entire criminal record, not just a specific felony underlying his disabling offense. So I think it is important to look at the entire big picture and not just say that all drug traffickers or all robbers or all people who commit a specific class of felony should be disabled from possessing a firearm. I think Bruin requires the courts to look at each case individually.
But isn't the real problem in this case, and this goes back to my question on the Rahimi case, looking at this temporal piece of it, is this presumption that the juvenile who becomes an adult is indefinitely dangerous. I mean, isn't that the real problem that we have here, is this indefinite presumption of dangerousness that will carry with this person into adulthood?
I think that is a problem. I think you're, despite what the state says, I think you have to look at juvenile adjudications differently from adult convictions, because I think it's interesting when the court just asked Mr. Wessels, what founding law can you point us to that talks about disarming individuals convicted of felonies, and there isn't one.
Well, permanent disarmament, right?
Correct, permanent disarmament.
So, because you stood up here saying that you didn't read the court's opinion to say that all juveniles could never be barred from having a gun, right?
Correct.
So there could be situations where what you're admitting is a juvenile delinquency adjudication, there could be situations where the person couldn't have a gun, maybe for a period of time, right? Into adulthood.
I think that would certainly be possible, and once again, I think it depends on that specific individual.
Okay. But then how does the statute that allows the person to go and request to get their gun rights back, how does that come into play in our analysis?
Well, I mean, that, Mr. Thacker could have petitioned the court to get his gun rights back, but there's no guarantee that the court would ever grant him relief from disability. All courts, all judges handle those things differently. There's no guarantee that he would even be living in the state of Ohio, and if that was the case.
There's no guarantee. I mean, he would have to demonstrate that he was living a law-abiding life. So are you saying that the existence of that statute does not come into play at all in our analysis of the constitutionality of this?
I mean, I don't necessarily say that it does not come into play, but it is, Mr. Thacker is under a permanent disability where he is unable to possess a firearm unless he petitions the court to either have his juvenile records sealed, apparently, or to file for relief from disability. But once again, there is simply no guarantee that he would ever get that relief, and it could be a lifetime ban from possessing a firearm. I think it's something that certainly the court could take into consideration, but there is just no guarantee that he would ever get that relief if he were to apply for it.
So if I'm understanding you correctly, what you're saying is that because there is no automatic relief from disability, in other words, if, for example, there were a 3 or 5 year period that somebody who was adjudicated delinquent for trafficking, 5 years after they reach majority, but because there is no automatic restoring of that right, it's unconstitutional as applied.
I think if there were a limit to the length of the disability, I think that would perhaps make it more constitutional. I don't know that I'm going to concede that a 3 or 5 year disability.
I know you have other reasons, but that would be a factor towards making it constitutional.
I think if it were more of a temporary bar, I think that would certainly make it appear more constitutional, absolutely, instead of a lifetime ban that Mr. Thacker would have to take some type of affirmative action on to relieve himself from that disability. So I think there is a difference, and I think that could make a difference if there was a limit on how long that ban lasts instead of a lifetime ban. I mean, he's 16 years old, so we're talking about 50, 60, 70-year ban potentially if he never applies for reinstatement of his rights. And I just want to reiterate that I do think the court has to consider the fact that this was a juvenile adjudication, not an adult conviction. I know the Supreme Court has held previously that juvenile adjudications can be a disabling offense for weapons under disability, but all of those cases were decided pre-Bruin, and I think Bruin really did change the landscape in deciding these types of cases. Juveniles, they don't have the right to a jury trial. They don't have the right to a speedy trial. They don't have the right to a public trial. And if you look back in historic times, juveniles had all the same rights as adults because there were not any juvenile courts established until the early 1900s. So juveniles back at the time when the Second and 14th Amendments were passed, they were treated just like adults. As this court just said, they were put to death. They were treated the exact same way.
So I'm struggling a little bit with this. So Bruin tells us to look at what was in place when the Second and 14th Amendments were enacted. And back then, as you just said, juveniles over the age of 7 were treated as adults. So if we're supposed to look at that time for the laws that were in place at that time, but you're saying that we can't look at how juveniles were treated at that time, or we shouldn't differentiate juveniles because at the time they were treated as adults. So I'm struggling just a little bit with this concept. So we're supposed to look at the historical tradition for what the gun laws were, but not for how juveniles were treated, correct? And I'm struggling with this.
I understand what you're saying, but I think the difference is if Mr. Thacker had been arrested for, and the other thing is there were no drug offenses. I don't think drugs were criminalized in the 1700s and the 1800s. So that's the other thing the court has to consider. We don't know how the founders would have considered somebody in possession of an illegal drug because I don't think it was punished until, I think the first federal laws on drug possession were not enacted until the 1900s. So if Mr. Thacker had been charged with this offense, however, theoretically, if it were an offense back around the time of the enactment of the Second and or the 14th Amendment, he would have had all the same rights as anybody else charged with that. He does not have these rights.
Including a jury trial.
A jury trial, a speedy trial, correct. So, the state has the burden to demonstrate, to show some type of historical analogy to a similar law like what we have before the court, banning somebody adjudicated of trafficking marijuana 13 years ago, and they cannot point, they certainly can't point to a twin, which I concede they don't have to do that, but they can't even point to anything even close to it because there isn't anything, and that's their burden. That's what Bruin says that they have to do, and if you read their brief and you hear what the state is saying today, they can't do it. The brief talks at length about gun restrictions on juveniles. Well, that's not what we have here. Mr. Thacker is 29, 30 years old. He's not a juvenile. This is not about restricting the access of juveniles to firearms. It's about restricting a law-abiding citizen from possessing a firearm. I would argue a marijuana trafficking adjudication as a 16-year-old does not make Mr. Thacker at the age of 29 a dangerous individual. In fact, he was doing what exactly I would argue the Second Amendment was intended to do. He was possessing a firearm because he was defending his business and his residence from intruders. So he was possessing a firearm for lawful purposes, for self-defense purposes, which is, I think in part what the Second Amendment is intended to do. So I am asking the court to affirm the lower court's decision. The state is not able to point to any sort of regulation that is even comparable to this that would restrict somebody who's adjudicated on a nonviolent, low-level offense from possessing a firearm for the rest of their life. So we are asking the court to affirm the decision of the lower courts.
Okay, thank you.
Thank you, Your Honors.
I want to briefly address that I don't think the self-defense argument is properly before this court. I mean, as far as I understand it, Mr. Thacker has gone to trial on those other charges against him, and at least on some of them has already been convicted by a jury of his peers, so I don't believe they should be considered here. I think ultimately one thing that I heard discussed was, and I want to be clear that we're truly dealing with the Second Amendment and not a policy decision for either Mr. Goldberg or this court to make. I mean, when it comes to the decision of this determination, whether or not the principles are being matched between today and before, the ultimate determination about whether this type of adjudication is a proper determination for dangerousness has already been decided. The Ohio Supreme Court has already said that inherent in this law is a policy decision made by the legislature that allowing weapons in the hands of individuals with certain prior juvenile adjudication poses an increased risk to public safety. They say that juvenile adjudications involving those offenses presents a danger. And so at least the automatic determination of is someone who's adjudicated of this offense a danger to the public, I believe.
Trafficking.
Correct, drug trafficking, I believe has already been determined by the Ohio legislature and is not the purview of this court. Then later.
But what about the idea of this indefinite
So then I think that the later, we have to ask is the later determination of whether someone is continuingly presenting a danger in order to keep them from having a firearm possession. I think it does comport with the principles inherent in our tradition to allow a court to make that determination, which is what Ohio law is set up to do.
So you're saying it is constitutional to presume that somebody adjudicated as a juvenile of drug trafficking can be disarmed permanently unless and until they convince a court that they should get their gun back?
Correct. I don't think it is unconstitutional to require some action on the part of the person who has been disabled to have to apply and make a showing to a court that they are in fact leading a law-abiding life and can be trusted with a
That's what makes this constitutional as applied in your mind, is the fact that we have this statute.
I think what Bruin says is there is the burden that is actually on the person's Second Amendment rights has to be comparably the burden has to be justified. That comparable burden, I think, is the word that they use in Bruin. And to the extent that I compare Ohio's law to some of these other federal laws, I think the burden is lesser on a person who is completely unable, for example, under federal law, to have their firearm disability removed. And so to that extent, I do think that it weighs more on the side of constitutionality when Ohio has multiple processes whereby someone can be relieved. I think it comports specifically with the firearm tradition. Just briefly, I wanted to point out that in Rahimi, they were dealing with a civil protection order hearing. There was no jury of their peers. There was no right to a lawyer. And in that case, I think both sides conceded that they were not going to find a one-to-one domestic violence civil procedure process at the founding. Women, it was the issue there, were in effect property in a lot of respects. They didn't have the same rights. And yet, when the 8 justices focused on the principles, on whether or not we can dispossess dangerous individuals, they found that law to be constitutional.
Because it was temporary, though.
I don't think that was the only consideration that they went into, is that it was temporary.
It was a consideration.
It was a consideration.
Yeah.
And so I would say, considering the scheme that we have set up here, I do believe that the law is constitutional. Thank you.
Okay, thank you. Your case has now been submitted, and we will issue a timely decision. Our last case is State v. White. Would you like to reserve time?
5 minutes for rebuttal, please.
Okay.
May it please the court, Mr. Hill. Candace White's 4-day absence from her house at 9667 Gertrude Lane was due to a domineering boyfriend and not an intent to discard her dogs. She's convicted of abandoning animals, and that statute reads that no owner or keeper of a dog, cat, or other domestic animal shall abandon such animal. And the 5th and 9th districts have defined abandoning as an intent to totally discard. And so,
Gee, what exactly is the purpose of the statute?
I think it's to prevent people from getting rid of their pets that they don't want any longer. And it has nothing to do with their treatment before that, I think. You could take it to a groomer. You could get it all up to date on its shots, a dog, for example, and feed it well. But in 30 seconds, you could leave it behind a dumpster, and it would be abandonment. You'd take the collar off so nobody could tell it was yours. It would be like handling contraband.
Hope it's not chipped, too.
Sorry?
Hope there's no chip in it, too.
Yeah, I know about that. Yeah, that would be incriminating. But I think abandonment has to do with discarding, like you would cocaine or obscenity, some kind of contraband. You'd want to disassociate yourself with it. You wouldn't want to be caught with it. And the cases that I cited all had to do with people that were being using stealth to get rid of their animals. They closed businesses, closed vet places, side of the road. They'd probably look around to make sure nobody was seeing them and then leave the dogs.
So this entire case hinges on what definition of abandonment we use, right? Because you talk about the 9th and the 5th districts, and they use the definition to totally disregard or discard the property. But then there's also the 2nd district, which said abandon is defined as to leave someone, especially when doing so amounts to an abdication of responsibility, which seems like what we have here, right? So if we use that definition, wouldn't there be sufficient evidence in this case that your client
I don't think
abdicated her
so.
responsibility?
I think either definition is kind of inadequate, because I think the abandonment involves with some disassociation with the animal.
We have 4 days where these animals, at least, were not fed, and there was one of the animals in a pool of cold water in the basement after a pipe burst, and she hadn't gone back to check on them.
I know, it's.
I mean, it's bad, but I'm just asking as far as like what definition of abandonment we use, because if we did use, my question is, if we use the 2nd district's definition, would there be sufficient evidence of abandonment, an abdication of responsibility?
Under that definition, I guess there might be, but I still think it limits what the essence of the offense is. I think you have to, abandonment is where you actually are trying to get rid of the animal.
Forever.
Well, you're trying not to get caught with it. You don't want it anymore, but you don't want it tied to you anymore. So you wouldn't commit abandonment if you'd leave the collar on with your name and address on it. You'd commit it by taking that off and taking the chip out or whatever, and then leaving it.
So you're saying it's about intent, not the
about
fact.
intent.
So it's not the fact that if, for example, somebody were to go on vacation and just not have anybody take care of their pets, that wouldn't be abandonment because they intend to come back. But if somebody, if somebody were to actually move and leave their animal in the house, their intent, it's about the intent.
Right.
Okay, so, what you're saying is that, why are we bound to the definition that I can't remember which courts it was, the courts that are saying that it has to be an intent to permanently abandon, rather than leaving an animal, especially when it amounts to abdication of responsibility? Why are we bound to the permanent intent?
Well, because I think it's more consistent with the word abandon. Abandon is not really a word that needs to be defined. Abandon is pretty clear. And
Apparently not, because we have districts in Ohio that are debating what the meaning of abandonment means.
well,
We have-
it's being debated now, but I think the facts of that case, I think we're talking about the Harding case.
Yes.
That's the one where, under the facts of that case, you would have conduct that would meet either definition. I mean, dog was left on the side of a road where nobody would, it was clear that the woman tried to disassociate herself with that. She lied about it even, not my dog, and they caught her because of her prior contact with the animal shelter. And so that's what I'm getting at. I think that wasn't so much what she did, it's my client that makes her conduct culpable. It's how she did it. She committed cruelty, but she did not abandon the animals. They remained at the house she was leasing. A mailbox was full of mail that identified her. She didn't try to say that weren't her dogs. Those were her dogs, all the way to the end when she cooperated with the officers. She never expressed an intent to abandon, to discard, or.
I just question where you draw the line, because yes, the dogs were in her house, and it was still her house, and we have 4 days here.
Right.
And then I question, what if she left for a month or 2 months, but she always intended to come back? Are you saying that still wouldn't be abandonment, even
That
if
would
these
be
dogs starved to death?
Massive cruelty?
But not abandonment?
I don't think so. They were hers, but she wasn't treating them well. She was, fatally
And the judge found her not guilty of cruelty and guilty of abandonment here.
Let's see. That's correct. That's what happened.
It's
per the
very
judgment
strange,
entries. Yeah.
strange verdict.
I mean, it seems like the trial court on the record, said that there was a guilty finding for cruelty, but then on the judgment entry wrote the opposite thing.
It cuts
Would you
both
agree with
ways,
that?
though. I can't benefit from that, and my colleague can't argue that there should be a different conviction. It's just off limits.
Right, so what's on the judgment entry is what we're
Correct.
stuck with.
Right.
Yeah.
And the judgment entry reads abandonment for the both dogs, but they weren't abandoned. She wasn't caring for the dogs, and they were always her dogs. So if there are no further questions, I'd ask that the court would reverse the conviction.
Okay. I'll reserve the rest of your time.
Yes, sir.
Good morning, Your Honors.
Good morning.
I'll start off by, I believe it was your question, Judge Bach, what the purpose of the statute is, or perhaps it was Judge Krause's. You have people who assume responsibility for animals when they take them in and make them their pets. And I believe the purpose of the statute is basically to prevent people who have assumed responsibility for these animals and leaving them in such a manner that they're, not being cared for, because animals are reliant on humans, they're domesticated, they can't necessarily fend for themselves, where you end up in a situation like what we have here, where these dogs, my take on this situation is that the defendant more or less left them to die, ultimately. I would just remind the court that we're talking about sufficiency and weight of the evidence here. They're both highly deferential standards of review on appeal, particularly sufficiency, where the evidence has to be construed in a light most favorable to the state. Now, I know.
Well, it seems like the sufficiency analysis comes down to which definition we use. Because, I don't think there was necessarily evidence that she was never going back, any evidence that she was never going back to the house. So her being gone from the house for 4 days, what was that abandonment under the definition of permanently abandoning?
I think in a sense it may have been, because there was also no evidence, and again, it has to be construed in a light most favorable to the state. There was no evidence that she was going back or that she had any imminent intention of going back. And had animal control not shown up, they would have been left to die. Those dogs would have, well, at least the one, I believe Kona, the 8-year-old shepherd mix, would have drowned in her crate.
So just because the dog is in a house that she continues to own, you're saying that there would need to be some sort of evidence that she intended to return
Well, I think more importantly, and I think this applies,
imminently.
well, at some point, you were touching on this with Mr. Hoffman, where do you draw the line here? But I think more presciently for purposes of the state's argument here, you've got these two standards. Certainly, I believe we win under that abdication standard. She abdicated pretty much all responsibility. She was only intermittently showing up at this house to give not even the bare minimum of care. These dogs were losing weight. They were really slow roll, starving to death. But you also...
I don't know what's going on with that.
You had testimony from the mom that her intention was to rehome those dogs. If you look at State's Exhibit A, when I believe it was Deputy Hudson shows up to interview the defendant on scene where she was living at the time, because she was not living with these dogs. She was obviously separate from these dogs. She didn't really seem all that concerned about their well-being. She seemed more concerned about the fact that she was in trouble. And when they said, hey, we're taking the dogs, she was like, great. So, she wanted these dogs clearly out of her life. So I think there is enough circumstantial evidence based on that. The way these dogs were being treated, where they were being left for days, if not a week at a time, not being fed, not being, given water, hydration.
So, back to, if we were to use the definition that there has to be an intent to permanently abandon these animals, the cases on that all seem to involve somebody leaving it at the side of the road, leaving it at a building and taking off, and actually leaving the dog somewhere other than their own
Right.
house. Have you found any case law that of a similar situation where somebody just simply didn't come back to where they and the dogs lived, or a situation where it wasn't abundantly clear
Right.
that they were trying to ditch the dog?
Well, I mean, this is really kind of a more of an ambiguous middle ground situation, right? And obviously, these cases don't crop up that often, and they
Sure.
probably don't end up on appeal, which is why we're talking about the 5th District, the 9th District, and the 2nd District. So you're kind of in a position where you have to make that call, I think. But I would just note again that, you know, sufficiency of the evidence, at least as far as sufficiency is concerned, is a highly, highly deferential standard. Everything has to be construed in the light most favorable to the state. And just based on, you know, mom's testimony that she wanted these dogs, you know, her testimony that she was only, I mean, even if you believe defendant, which I'm not sure I do, she hadn't been there for 4 days. There was no indication that she was going back anytime in the future. The reasons for that I know were in dispute, but, you know, I think.
There was no indication that during those 4 days she had asked somebody to feed the dogs.
There was or there wasn't?
There wasn't, was
No,
there?
no.
That she had asked somebody to do it and they just didn't?
No.
Okay.
No, and there was additional testimony that even she, you know, wasn't necessarily the one going to do this. She would have other people go to do it, whether it was her mom or maybe another relative. Certainly, under the 2nd District standard, she had abdicated responsibility for those dogs. She left them, you know, for all intents and purposes, to die in that flooding basement. And I believe it was not in evidence, but there was some representations in the state's opening and then as well as the sentencing that one of those dogs did ultimately die as a result of.
Yeah, but that wasn't in the evidence, that was
Right,
just.
it wasn't in evidence. I'm just pointing that out here. But yeah,
But you're arguing that, are you asking us to pick a definition of abandonment, or are you saying under either
I
definition?
think we could win under either potentially. Certainly, if I had my druthers, he would pick the 2nd District's definition here. But I think we can win under even the definition that they've cited, the 5th and 9th District's definition, because it was, you know, abundantly clear from the record that she wanted these dogs out of her life one way or the other. She basically picked this boyfriend over these dogs. So unless the court has any additional questions, I'll cede the floor. Thank you.
Okay, thank you. Mr. Huffman, you have about 7 minutes remaining.
Thank you, Your Honor. If Candace White wanted to abandon these dogs, Brian Thompson would have jumped at the chance. All she would have needed to do is ask him to leave them somewhere, and then that would have been abandonment. He didn't want the dogs. She wanted the dogs. If the second definition, if the state's definition, if the definition of the, of Harding is adopted, the abdication definition, there'd be too much of a blending and overlap between cruelty and abandonment. I mean, where does cruelty end and abandonment begin? Would you just pick all ultimate or seriously cruel situations and call it abandonment when it isn't abandonment? Like in the scenario I gave at first, abandonment may have absolutely nothing to do with prior cruel treatment of an animal.
Well, I mean, cruelty could happen even if the owner has no intention of abandoning the animals. I mean,
That's true.
If there's dogfighting, for example, or if somebody is torturing a dog and they don't intend to leave it, but,
Right,
I mean, that could certainly happen without abandonment.
right. One final comment. The court asked about a case involving an animal that was kept at the owner's house and an abandonment charge being made. That was Hull, where it was the defendant resided in a rented house. He didn't care for the dogs in the house. And the only difference between that case and this case is that he was residing there and my client wasn't residing at this house. But in both cases, there was no attempt to disassociate the owner from the dogs. In both cases, the court found that there was insufficient evidence of abandonment because the dogs were kept at the house that was rented by the owner.
Wasn't the situation in Hall, though, and correct me if I'm wrong, that there was actually evidence that someone was returning to the property during the relevant time frame in that case?
There is that language in there,
But
yeah.
we don't have that here. We don't have any evidence that somebody had come to the property in the last 4 days.
That's true, but I would argue that that's not the pivotal part of the case. I think the pivotal part of the case is that the The dog was kept at the residence of the owner, and the owner did not attempt to disassociate himself from the dog. It was still claimed, he claimed that dog the whole time. It's just that he wasn't caring for it, and the same thing is happening here. And in both cases, I believe that evidence is insufficient of abandonment. If there are no further questions, I'd ask the court would reverse.
Okay, thank you. Okay, that concludes our cases for today. Well, that stays.
It's court property.
Yeah, that's the timekeeper.